Hi, welcome back to Space Thoughts. What I'm going to do in this video today is revisit a video I did 2 videos ago on the idea of Article 9, and in particular this idea of due process and harmful interference. Now, if you recall back then, and again, I'll link this video at the end of that video at the end of this video. If you recall, I talked about how due process really isn't something that's defined, but rather something that is implemented in the succeeding sentences or paragraphs of Article 9, as far as what due regard is actually what actually becomes. Now, I really thought about this for a while, and I actually wrote a briefing letter on Article 9 in national security activities, and I really thought this through a little bit more. And really, this whole idea of due regard isn't really something that's supposed to be defined. Now, I know people want definitions to try and make to make it easy. But the idea of due regard really isn't supposed to be defined. You cannot give it a legal definition or even a legal test for that matter. I think I went in the last video, I said maybe it should be a legal test. It's not quite a legal test, but rather what it is, a duty of care. And within that duty of care, there is kind of a legal test to determine whether or not there is negligence in terms of activities that are performed. Now, I'm going to get a little bit into tort law here, first year law school tort law, just so you can understand where I'm coming from. In tort law, in negligence cases, basically what happens when a jury or a judge looks at a matter, what the plaintiff is trying to prove is that the defendant didn't meet what we call a reasonable person standard. In other words, they weren't acting. In other words, a reasonable person standard goes like this, somewhat like this. What would a prudent person in a similar or same circumstance do in terms of these activities? In other words, what would be a reasonable way to do these activities that wouldn't cause injury, harm, or damage? Now, basically, if a jury or a judge determines that the defendant didn't act as a reasonable person in that respect, then they'll fine for negligence. So, and it says different. Strict liability is a little bit different. It doesn't apply the reasonable person standard, but basically, this reasonable person standard is the duty of care that's put on a person performing an activity. Now, the reasonable person standard that I kind of articulated there differs depending on what's happening. Like, for example, if you're a legal professional like myself and you're being charged with negligence, the standard would basically, the test would be for the standard of the duty of care is, did this person act as a reasonably prudent lawyer in the same or similar circumstances? And if, of course, if he or she didn't, then they'd be found negligent. If it is found that they did, they wouldn't be found negligent. And again, this whole idea is when we're looking at this, we're looking at it from what we call an objective point of view, an objective standard when we're giving this test. I think due regard is the same way. It's not really a defined term. There's not really a legal test to it, but there is a duty of care. And I think that duty of care can be articulated very simply as what would a reasonably prudent state actor or non-governmental actor do in a similar or when performing a space activity in outer space. So in other words, if there's an incident in outer space, one of the things is you have a duty of care. Basically, you're going to have to ask as a reasonable space actor when performing that, whether you're the government or you're a non-governmental. So if something happens, basically you've not met that duty of care, and you basically could be found negligent or liable, what have you. Now, the big problem here with this is space activities are still relatively new. We haven't even invented some space activities yet. So really, this whole idea of this test for due regard, this duty of care, it's going to vary from activity. For example, rendezvous and proximity operations. If basically the duty of care might sound something like this: what would a reasonably prudent state actor or non-governmental space actor do when performing rendezvous and proximity operations? However, if we're on the moon doing space resource activity on lunar surface activities, the standard of care will still be articulated similarly, but it'll be different because it'll be a different activity. For example, what would a reasonably prudent state actor or non-governmental actor do when performing these lunar surface activities? And the whole idea is in order to really have this standard of care, to be able to articulate it, to be able to decide whether or not something's reasonable or not, you got to know what this type of activity actually implies. And I'm just going to go back to something I used last time. And this is basically Article 9 broken out, and we're talking about this idea of due regard here. And basically the whole thing is with due regard to the corresponding interests of all other state parties to the treaty, and that includes other non-governmentals as well. So fundamentally, the whole idea is within that little sentence, term of due regard, that undefined term, that legal test will apply. If I'm doing rendezvous and proximity operations, I have to do it as a reasonable state actor would, performing the same or similar rendezvous and proximity operations. But again, these are still fairly new, so we don't know we're not really quite sure what is reasonable and what isn't reasonable. That could change. I know there's a group called CONFERS. I used to be an observer with CONFERS. They're basically an industry organization, and they're developing standards for these idea of rendezvous and proximity operations. If these standards are found internationally acceptable, then if something happens, then you can actually apply the site. You could find out what due regard really means in terms of rendezvous and proximity operations. However, on the other hand, if you are on the moon, if we're on the moon, we're starting lunar surface activities, we haven't quite developed enough practice to understand all the ins and outs of it, it's going to really be hard to articulate what due regard really is in that sense. So in other words, this idea of due regard, it really isn't developed yet. It can't be defined. I know a lot of people want to slap a definition on it and make it simple, but this isn't really a simple topic. And I think by trying to make it simple with a definition, you're going to make it more complicated, and hence, and make it less simple, less easy as it can. In other words, if we take due regard as an undefined term that is basically a standard of care or a duty of care, we're going to simplify what is otherwise a really complicated thing. However, if we try to just slap, a blanket definition on it, we're not going to be able to. It's going to make it more complicated than is necessary, and we're never really going to get around to finding what due regard is. So before I go on, I really want you to understand due regard is a duty of care. And if you Google it, you can go on a search engine and type in duty of care, and there's a lot more explanation as to what that really is, instead of, besides what I just tried to explain earlier. And again, first year law students, we go through this in torts 1 and 2. So this is pretty much drilled into us from day one. So again, I mentioned in the last video that this first sentence and due regard is basically implemented in the successive sentences of Article 9. I'm just going to go through these really quickly. State parties basically, the next one is a planetary protection duty or obligation. And due regard in that case, or the question of duty of care, would be in performing outer space activities, are states acting as reasonable operators? In other words, are they performing these duties as a prudent state would in terms of decontaminating spacecraft going to other celestial bodies, or coming back from celestial bodies in that sense? Or in other words, is the science being performed as a reasonable, prudent scientist or reasonable, prudent space actor would perform it? So the next one, though, is we get into this idea of harmful interference. And what is harmful interference? Well, again, this is another term that people want to define. In fact, there's another organization I'm an observer with. They're called GIGSLA for short. It's affiliated with Moon Village. They're actually trying to make this actual define harmful interference. And I think that's really kind of difficult, because just like due regard, the duty of care for due regard isn't going to be the same for every space activity, because every space activity is very specialized and it's going to be different. There may be similarities between space activities, but they're not going to be the same. So the whole idea of this idea of harmful interference, or preventing a harmful interference, basically implements due regard. Basically, you're going to, if you're not acting as a reasonably prudent person or a space actor when performing, say, rendezvous or proximity operations or lunar surface operations, then you're probably going to end up causing harmful interference, especially if it damages or injures or otherwise interferes with another state actor or another non-governmental under the jurisdiction of another state actor. So again, the idea is harmful interference is a very fluid definition, and it's something that's going to be is going to be pretty much tied with the idea of due regard based on each specific space activity. In other words, we're not going to have one legal test of due regard for every that's going to encompass all space activities, because bottom line is space activities are very specialized, and they cannot, you really just can't lump them all together, especially when it comes to this idea of what's a duty of care and what is harmful interference. I mean, going back to the Moon Village organization that is actually trying to define harmful interference, their definition might work for lunar surface operations, but it's not going to work for something like rendezvous and proximity operations or some other operation that is basically not akin to what's happening on the surface of the moon or other celestial bodies. So the idea of defining this idea of due regard and harmful interference is really nonsensical in my opinion, and really it's futile, and it's something that it's going in the wrong. When you're trying to do that, you're going in the wrong direction. The whole idea is understanding that due regard is a duty of care, and we can't define and because we don't know what these space activities are going to be like, because we don't have standards for these types of activities, it's going to be hard to tell what due regard is, and hence harmful interference. The first one, planetary protection, we pretty much got that down. We know what due regard for planetary protection is because we've been doing it for so long through scientific missions. The real test, I think, we've actually brought samples back from a celestial body at the moon. We'll see what kind of what due regard means when we return samples from Mars or asteroids or what have you, or even abiotic space resources. With that, I want to just point out one other thing. This whole idea of due regard, this whole thing of duty of care, in torts, usually this reasonable person standard I told you is what we call an objective standard. In other words, what a person would objectively see, an average person, an average citizen who is looking at this, what they would think is, reasonable or not, just based on their experience, based on what they know about it. Because space activities are so specialized, and because they are going to be so politicized, given state interest, because of state jurisdiction and state responsibility, I think the idea of due regard, as far as a duty of care, is going to be a subjective standard. In other words, it's going to be subjective to geopolitics and political state interests. In other words, when evaluating whether due regard has actually been followed, an expert and experts might say for a particular space activity, yes, due regard, maybe acted as a reasonable, prudent space actor in this particular situation. However, the state, which has the ultimate responsibility, might say, no, we either we don't agree or we do agree, and that's why this thing is going to be subjective. It's going to be very sticky, I think, because states are being ultimately liable for these activities are not going to assume liability, and they're not going to admit liability, and they're going to fight. They're going to push back on it. So I think there's going to be a subjective state standard because of the specialization and because of this whole idea of state interest, which is not going to go away anytime soon. One other thing I want to talk about is potentially harmful interference, especially when it comes to this consultation requirement. People talk about harmful interference all the time, but what they're missing the modifier with potentially harmful interference, and that's critically important, especially when it comes to triggering the consultation requirement. Now, the consultation requirement right here, undertake appropriate international consultations before proceeding. What this all came out of was this thing called Project West Ford back in 1961, I think, is the first time. First batches of bipoles were launched. Basically, what happened is the Air Force and MIT labs got together, said, you know what, we're going to try and launch these little iron dipoles in orbit to see if we can create an artificial ionosphere to bounce radio signals off from. And basically, what happened was the first launch they launched about 70. They were supposed to launch about 75 pounds of these dipoles in orbit. And basically, COSPAR, which is a big organization that deals a lot with these matters, and basically planetary protection guidelines or advisory guidelines, went bananas over it. I mean, they just absolutely melted down. The Soviet Union melted down too, and that was more politics than anything else. And the Kennedy administration had to do a lot of backpedaling, appointed its own committee, and said, okay, before the next launch, we'll make sure that we study any harmful effects. Well, COSPAR was very insistent and said, we want to be consulted before that happens, before you do any launches of experiments like this before. And that's where this consultation requirement came out and basically developed into Article 9. Now, I think they got a little bit, honestly, I think they really got a little bit carried away. They overcompensated, and I think emotions are running a lot high when they came up with this consultation requirement. And a lot of it has to do with this word potentially. Now, potentially is something that basically in my definition and the way I use it is basically the idea of, could anything possibly happen? I mean, and I think the question would be, are you 100% certain nothing can happen? And of course, the answer is no. I mean, in outer space activities, there is always the chance that there's going to be some sort of harmful interference, no matter how minuscule. The problem is what potentially is it just opens up the breadth to the point where this consultation requirement, anytime you want to do a space mission, that potentially would just absolutely, you'd trip that wire and the consultation requirement would be tripped. Now, that has never happened in over 50 years. That's never happened. And I think a lot of it has to do with the fact that the delegates, that the science community may have overcompensated when it came to this idea of potentially harmful interference. And I mean, going back to Project West Forward, and I think basically they got to the point where states are looking at it saying, do we really want to trip this and set a precedent? I wrote a special issue, my briefing letter about this. Basically, my focus was on national security activities, how the rationale for why I think national security activities are basically excluded from this, and that's something for my subscribers. That's basically premium subscription behind the paywall type of content. I won't discuss it here, but what I want to get to here is I think that they created such a easy tripwire for this consultation requirement that states have really been reluctant to trip it. And I've seen a lot of things a few things recently that this was something that states would probably trip in order, given this idea of potentially harmful interference, but nobody has. It's almost like opening Pandora's box. Nobody wants to open it because once it's open, they're not going to be able to keep it shut again. And there's a lot of other reasons, geopolitical, lawfare type things in there as well. And that goes the same with the idea of this right to consultation. Now, the way I see the right to consultation is basically looking at one state looking at another saying, hey, you're going to be doing a space activity. We got wind of it, but you're you're supposed to be consulting because of that potentially harmful interference that it might, this even 1 in a million chance it might cause harmful interference. You're not going to trip that consultation requirement, but we're going to. So in other words, they're going to invoke this right of consultation and basically trip that wire and force the other state to do that. Now, that has never happened, although it happened once after China tested its ASAT in 2007. After the fact, Japan came in and basically asserted the right to consultation. However, the key in the right to consultation is you got to do it before the space activity occurs. You can't do it afterwards. So I don't think that was really a proper invocation of the Article 9 right. So just in my opinion, just like the duty to consult, the right of consultation hasn't been tripped yet. And personally, I don't think it ever will be, just because the way it was set up, I think it's just so onerous and so easy to get away from, and it's just so easy to trip that I don't think any states want to actually go down that path and open the Pandora's box, because once it's open, and you got a lot of potential for harassment in the geopolitical sense. It's a good lawfare tool. So I want you to kind of understand that as well. I mean, that's something that is, I think, we talk about a lot of people talking about, well, they have this duty to basically invoke this duty to consult. I don't think anybody's going to trip it. And of course, in my opinion, national security activities don't fall under Article 9. My reasons for that are outlined in my briefing letter, the Pressy. And basically, this is the cover page for my latest special issue of the Pressy, where I talk about Project West Forward. I talk about Article 9 and basically go into a lot more detail what I talked about here, due regard, harmful interference, potentially harmful interference, why I think it's something that's not going to be invoked, and such. And of course, I talk about my rationale why I think national security activities are exempt from the Article 9 consultation requirement. So I'm going to, with that, I am going to leave you with that. Again, Article 9 is a crazy provision of the Outer Space Treaty, but I think that right to that duty to consult and that right to consultation, I think it's it's an aspirational type of provision, but I don't think you're ever going to see it invoked. So that's all I have for this video. Until then, have a great day, enjoy the weather, and we'll talk to you next time.